Welcome again, and this is the conclusion of our fourth part 1. And what I tried to do is present you with a case to show you the dilemma that we have between ethics and the law, and when it comes in a court of law especially. And again, it's a case, the gubernatorial case is a very interesting case. In 1982, in the closing days of Minnesota, so you know that this case will be argued in the court of Minnesota. But the thing that's very interesting about this case, that it went through the lower court, the appellate court, and the Supreme Court of the state. And since the newspaper, I'm not going to reveal yet the decision, or the other party lost, you have a right to go all the way to the Supreme Court of the United States. The interesting part about the United States Supreme Court is that they have every year 5,000 petitions, but they only can hear 200. And of course, you know that those 200 petitions that will be heard by the 9 justices of our Supreme Court will be decided by their law clerk. And then they recommend it, or they propose to the judge, to the justice, I should say, the cases to be heard. And then the 9 justices get together, and they're going to pick the cases that pretty much all the law clerks of the 9 justices agree that it's an important issue for them to make a decision. And they do not hear all the cases. They're not going to hear the cases that they will be damned one way or the other. For example, Megan's Law, it's a legal statute, but the Supreme Court will not hear it, because if they decided that Megan Law is constitutional, well, you're going to hear people say that's easy for them to say it's constitutional because they can afford to live in an area where no criminal that abuse a child will be moving in their town. And if they, of course, say that the Megan Law is unconstitutional, then the state is going to have a problem, because how can you say that it's unconstitutional to keep track of someone that is hurting our children? So that would be one case, for example, that will not be heard in the Supreme Court of the United States. We're not ready to yet to hear it. And what was interesting about this case, that I would like you to take your time to read it and to give you a little summary, is that the reporter wants to get some information from Mr. Cohn, and he's a gubernatorial candidate, and the reporter says, give me some information. Now, this information was or is public information, but he, instead of going to the library and doing research, he said, hey, can you give me the information? You know something, can you give me the information? And of course, Mr. Cohn says, I give you the information, but you have to promise me something. You have to promise me that you're going to keep the source confidential. I do not want the newspaper to put my name. So I'm going to give you the information. So here is the promise. It's almost like, hey, can you do me a favor? Or promise me you're not going to tell something. And we do that. I have something to tell you, but you promise you're not going to tell, to anybody else. Or don't tell my name, because I don't want anybody to know that I told you that kind of a thing. We do this all the time. However, when the information got back to the editor did what? The editor decided to reveal the information, because if he's going to put the information in a newspaper with anonymous, not many people's going to read it. But if he's going to put the name of the person, especially if he's a candidate running for the governor, people's going to read it, because we have to read what our governor to be says in that piece of information. So the editor really revealed the information. And this was very interesting, because then as soon as the newspaper article was published with his name, Mr. Cohn was fired by his employer. So Mr. Cohn then says, oh, that is nice. Here I am asking you to keep a promise, and next thing you know, not only did you breach the promise, but now I'm suffering damages. And in a court of law, to bring a case, first of all, you have to have a legal action to bring the case to court. The second thing, you have to have standing, which means you have to suffer some damages, because if you have no damages, why even bother to court? Well, he got fired. And of course, the thing is this, one of the biggest questions that's going to come is a promise, a contract, before we do anything. So for breach of contract, and of course, this is where we're going to have to discuss this in our bulletin discussion, and we're going to discuss what the court says. Do you think that the editor had an ethical duty to provide the public the coverage? And of course, the newspaper, just like the internet, will always use freedom of speech. I have freedom of speech. Now, freedom of speech against government. I have absolute right of freedom of speech. However, I don't have an absolute freedom of speech against another individual. I mean, I can say a lot of things against the government, and the Constitution will protect me because the Constitution protects me against the government. But if I say not nice things about somebody else at work, colleague, or a student, or a neighbor, I do not have an absolute, the Constitution will not protect me. This is very interesting. So here is a situation where the newspaper felt that they did not breach any ethical duty. There was nothing there. They have freedom of speech. There's their responsibility to reveal to the people what is going on. So this is the one question that I would like to you to discuss it. Was there or wasn't? The second one, did the reporter promise to keep co-identity confidential, create an ethical obligation or a contract? Now, what those two promised to each other is just something like it's an ethical, like a conscience, or was it really a contract that can enforce by the court? So you know the first thing that the court wants to hear now is that ethical, or was it a breach of contract? So you know that maybe the lower court says there's no contract, therefore they didn't have to do anything. The appellate court might reverse. The Supreme Court might remand to the lower court. The lower court then might settle out of court or might again start all over again a new trial. Very, very interesting. And the reason why I gave you this case because it went through fourth year. That means not only the people, the editor and Mr. Cohen did not know what to do with it, with the decision, but they had to go through the different judges in the Supreme Court to decide that. If the court decided that an enforceable contract was formed, okay, if there's a contract, and report how would this affect in society evaluation as expressed in the First Amendment Constitution. If there is a contract and the newspaper cannot reveal the information, what's going on here? If the newspaper cannot reveal the information, when is the newspaper not going to reveal the next information? Whose names they cannot reveal? That's another issue that we're going to discuss. And then, let's think of global economy. Does a transnational company follow the ethics of the parent company or of its host country? That's another big issue that we have in a global economy. And this, again, we're going to discuss our opinion, and I'm going to share the decision of the court on our bulletin board. And thank you very much.